Let's get started with the call. Niyati, you want to introduce yourself?
Yeah, so my name is Niyati Shah. I'm the owner of the Shah firm, and I'm based out of Dallas, Texas. And I've been in the immigration industry since 2003. That's been a really long time. I stopped counting. But so I've been practicing corporate immigration for a really long time. That's the focus of my practice. And I'm here to answer any questions you may have.
Of course. Thank you for being here, Niyati. We really appreciate it. Uh, Today, like Sachin mentioned, we'll be discussing USCIS, the settlement that was recently passed. I just wanted to remind all of us here that the information provided in the seminar is of general nature and may not apply to any particular set of facts or under all circumstances. It should not be construed as any legal advice and does not constitute any engagement with Niyati Shahs or establish any attorney-client relationship. Just wanted it to be clear for everybody here. So we can then go ahead with our call. Like Sachin mentioned, it's a huge settlement and a huge changes coming over for H-1B visa holders. So we would go point by point. We'll discuss this in detail. If anybody has any questions they would like to ask during the course of this call, please feel free to put them in the chat or raise your hand. We'll visit the questions in the end so that the chain of thought is not disturbed. Niyati, so let's get started. So the first point that we would be discussing right now is USCIS requirement of the employee-employer relationship. So what's the impact of the settlement on that? And would you like to throw some light on it?
Yeah, so I think going back to what Sachin mentioned, right? There was a point of time where what USCIS was doing was they were basically trying to interpret the law. So if you know a little bit about how the legal system in the US works, each branch has their own powers. And when there is regulations, the administrative branches, which is USCIS is one of the administrative branches, they're not supposed to interpret regulations. Interpretations are usually done from a judicial standpoint. So what USCIS was doing is that, okay, here is what the regulations say, but we think this is what it means. And so the employer-employee relationship specifically, what they started doing is they started putting in all these requirements that not only do you need to prove that you're hiring them, you're paying them, you are supervising them, you have control over them, and they basically interpreted it as a all-encompassing requirement, as opposed to if you just add instead of and you add or, you just have to prove one thing. So that's what the regulation said, that you have to either prove that you'll hire them, you'll pay them, supervise them, or control them. And because of that, this whole client letter and all of those requirements kind of came into play. So now, fast forward, once that settlement happened, essentially USCIS has come back to what the regulations say and what the intent was, that you need to only prove one of those things. So if you have an offer letter, that's good enough. If you have pay stubs, that's good enough. So just any one of those requirements essentially would meet the test.
Okay. Thank you for answering that for us. And we, as I mentioned earlier, we'll take any questions you might have at the end of the call. So let's move on to the next point. That is USCIS requirement to submit the detailed itinerary, like the detailed work order, client letters. So what's the effect of this settlement on it?
Right. So at some point, if you remember, they were asking for very specific day-to-day assignments, and providing an itinerary, providing exactly what the individual is going to be doing. And, those were some of the things that they were asking for. Now, fast forward to, after the IT settlement, they're basically it cannot be speculative work. So if you are basically hiring someone and you don't have a project, that's speculative employment. So you still cannot do that, but you don't have to provide proof of that necessarily. So I think you have to draw a distinction between what is allowed versus what happens if, from a practical standpoint, what you can do and what you cannot do, right? So on a piece of paper, you might say that, okay, yes, I do have a project, and that would be great. But if you are basically having that, I might have a project, I don't know which particular company, right? That becomes speculative. So you just want to make sure that when you are filing these H1s, you are very clear that, okay, there is a job available for this individual and we're going to be able to provide this particular job. It's not something that's speculative that maybe I can find something for him or her. That would not work.
Okay, sounds good. Yep. And let's go ahead with the third point, which is USCIS requirement to provide work details for the entire duration of the petition, like the bench period and everything. So, have you seen any changes to that?
Right. So now, because you're not required to provide a customer contract, right? So it
Mhm.
becomes very different. But again, you're going back to the same thing that if you have an expectation, a realistic, reasonable expectation, right? That, okay, this project is a long-term project. So then you can go ahead and file for the full 3 years. If your expectation is that, the client is clearly telling you, you have an email saying this is only going to be for, 2 days, and then you apply for 3 years, then that's a problem. But if your client is saying, yeah, right now I'm extending this for 3 months, but after that it's going to be continuous, we're most likely going to continue approving it, or there's a possibility, then it's not speculative anymore, right? So it becomes, yeah, so you can go ahead and do that.
Okay. The next point was the length of approval that people used to get. So, any you would like to shed some light on it?
Yeah, so ever since March, I think we've all been having conversations. What do we do? Do we go ahead and apply for 3 months, 6 months, 3 years? What should we do in those situations? And we've had many approvals. Actually, all of our approvals where we've asked for the full 3 years, they have all come through. So we haven't had any issues from a timing perspective. Now, I will tell you that if you're going to go ahead and submit information like contracts into your filing, then then the officers are allowed to look at that and curtail it and provide a reasoning. So they cannot just arbitrarily decide, okay, I feel like giving them 3 months or 2 days or 3 days, right? They can't do that anymore. They have to have a reasoning behind it. And that's where if you start submitting these contracts, which are not required, once they become part of the file, then the officers can actually look at them and make their decisions. So my recommendation is don't even provide that. As long as their focus has actually changed because of this IT Server Alliance settlement, from looking at contracts and things of that sort to the job duties. The job duties is the main thing that they're focusing on right now. From a practical standpoint, one of the other things that will come into play is benching. So one of the things that they have said is it's not enough just to pay the individual. It's you have to make sure that you have some sort of work for them, whatever that work might be. So if somebody is just, I mean, you're allowed to have transition from one project to another, no problem, as long as it's a reasonable transition. But now, if you're saying that 6 months is a transition, that's kind of pushing the line, right? So you have to kind of it's look into that. But it's not just kind of payment to the individual, it's actually making sure that they're working.
Got it, got it. And as a whole, the USCIS IT serve settlement, we went point by point to all the 4 points. But do you want to shed some light as to what all the 4 points summarize together? What's the big picture here that we have a big change here coming up?
I think the bigger change is that they were completely out of line. They had really gone to an extreme where this was unreasonable. And my take on it is that if USCIS was reasonable about it, I don't think there would have been so much of a pushback. But when you as an agency are kind of doing one day approvals, 1 month approvals, then at that point, I think the entire alliance started looking at it and trying to see that, okay, is this even a reasonable stance? And everybody, it was a very clear cut situation where they were completely out of line. So that's where now we've gotten to a situation where when the officers are reviewing it, the original intent of the regulations is coming out, that As long as it's a specialty occupation, which is a particular position that has a bachelor's degree in a related field. Now, this is very important because if you have something like bachelor's degree in business administration is required for this position, they
Mhm.
will start pushing back on those things. So the specialty occupation job duties are going to be one of the biggest things that you will look at. But overall, I think things have improved quite a bit. H1 transfers, H1 extensions, they've become a lot more reasonable in getting approved. You still have to make sure you're focusing on, the application and making sure it falls into the right categories and you're providing enough information for them to make that decision. But
Mhm.
yeah, it's gotten much easier.
Okay. Thank you for sharing your inputs with us. And now we'll open the floor for some Q&A. If anybody has any questions, please feel free to put it in the chat box or raise your hand so that we'll give you a chance to ask Niyati. I see a couple of hands raised, so let's go ahead with Harsh. Harsh, can you ask your question?
I think he's muted.
I'm trying to unmute him. Are you unmuted now, Harsh?
No.
Okay, well, good.
There you go. Finally. Hey, Niyati, good to have you among us. So I have one. Oh, okay. Okay. So I have one question for you regarding the impact on current H-1B processing time. So from what you've seen, is there a delay in getting H-1B nowadays in normal process, or has it got faster?
No, there is a, I'm guessing it's related to COVID, but you never know with USCIS. So with California Service Center, we're looking at 2 to 4 months. And I believe Texas Service Center is around 4.5 to 6.5 months. That's what we're looking at right now. So definitely there is a delay if there is a need for you to kind of get those, process faster, go with premium processing so that you can expedite those approvals.
Okay, thank you, Niyati. Any other questions? I saw a couple of hands raised, but they are gone now. Ajay Munish, do you? Oh, there, Munish.
Yeah, hi Niyati, Manish this side. So just continuation to Harsh's question that the time is still fine. We're getting normal approvals. So is this the same for RFE as well? Then when we get an RFE, so the turnaround time is same or is it uh, different there?
Yeah, so the RFEs will have the same amount of turnaround time, but the number of RFEs has significantly gone down, right? Because you don't, I mean, one of the biggest things that they were harping on is that the employer-employee relationship. So now if you're not submitting contracts, it's really gone down. So we can do a whole lot on our end to make sure that those RFEs stay low by making sure that you focus on the job duties. And I keep bringing that up again and again because I think it's very important that you guys focus on providing good job duties that are detailed, not very technical, but not very vague as well. So it's kind of like striking that right balance. A lot of times I'll see job duties that, from a technical standpoint, they make a lot of sense, right? But the officers, I think one of the I remember my mentor had told me this, and I still kind of stick to it. That imagine that you're preparing the application for an eighth grade level, because if you can convince somebody at the eighth grade level that this is a specialty occupation, it's an easy thing. So when you're writing out those sentences, complete those sentences, look at it from the officer standpoint that doesn't know anything probably about, from a technical standpoint. It's kind of like trying to convince a lawyer that, hey, this is a very technical position. But if you just kind of use a whole bunch of acronyms, lawyers as well as these officers are not going to understand, that technical nature of the job, and they will start wondering, okay, what does this mean? Is this really a specialty occupation? Can somebody go and get an associate's degree and do this job? So you just want to stop that. You don't want to kind of go to that level where that question pops up in their mind. So be very detail oriented with your job duties, and that will help you with avoiding those RFEs. But to answer your question, the same timelines apply. The clock stops Once you kind of get the RFE, once you submit the RFE, the clock will start again.
Yeah.
So the
That's a big,
consultant wants, yeah, go ahead. So,
mm,
as for the consultant's question, he always asks that, so if I get an RFE, what's the success ratio? They always get scared, when they get an RFE now, it's going to be hair and wire and they won't be getting the H1 approved. So, we need to answer those questions. So, what do you think, what is the ratio of success so that, we can let them know with confidence?
So I think if you're able to address that main question, right, as of right now, the main question that they can come back to you with is this a specialty occupation? So if you can do a good job explaining that out, that somebody without a bachelor's degree in a specialty occupation cannot do this job, it will be very easy. But when going back to your point, RFEs are not a bad thing. It's just essentially a way for the officer to ask questions, right? That's what it boils down to. So I know everybody panics, like, because of course everybody wants an approval right away. But if the officer is giving you an opportunity to respond, I think it's a good thing, because then it's up to you and your attorneys to kind of sit and focus on, okay, how can we best respond to this? And that's where I think I've seen many times that the employee will basically be like, oh, but I have to put this in there, and sometimes it's better not to put certain things. Not to say that you're trying to mislead. Of course, you need to still provide the right picture, but provide the right picture in the right way. There's a difference, right? Just because you think something is important doesn't mean that it's required under the
Right.
regulations.
Exactly.
So, yeah.
Yeah, sure. Thank you, Nidhi.
Sure.
Thanks.
thanks, Niyati. We have another question from Ajay. So, Ajay, here you go, Ajay. I unmuted you.
Yeah. Hi Niyati.
Okay, Jay.
I just one question regarding the fees. Is there any like increase in the fees also?
Yes, there is. And you know what? I'm trying to see if I can find that schedule. I have that schedule. But essentially, the I-129 fees, which is for the H-1B, did not have any increase specifically. But if you take a look at premium processing, didn't have any increase either. H4's, the new fee that will go into effect starting October 2nd, went up by $30. So it's, instead of $370, you're paying $400. EADs will go up from 410 to 550. The biometric fee, actually for non-DACA, which doesn't really apply in this particular, there is a decrease. I-140s will go from 700 and will now decrease down to 555. So that's at least some good news. 485s will go from 1140 to 1130, $10. And I-130 will be 535. It'll go up to 560. And then I-131s will go from 575 to 590.
Okay.
So yeah, so there is an increase that will go into effect starting October 2nd. There will also be, from your attorney standpoint, there will be a couple of forms that are also going to be changing. Those will all go into effect around October 2nd. So, where you have folks that are joining end of September, you might want to keep that in mind as far as timing is concerned, because if you get all of the information prepped, if you don't get it filed before October 2nd, then you're essentially looking at redoing all of those forms, getting all those signatures in place, and that might change everything by at least a week, maybe longer, depending on when the final forms come out. Just from a practical standpoint, many times what happens is USCIS will say, oh yeah, there will be a new form that will go into effect October 2nd. They go ahead and release it September 28th. Most attorneys are using these, they have their own softwares and things like that. So it takes time to kind of put those forms in place so that things can be generated. So from a practical standpoint, just be aware that, from a timing perspective, if you want to file it at least 5 days before October 2nd, and then expect that there might possibly be a delay where after October 2nd, you might have to wait a little bit.
Okay, so the fee structure-wise, there's not a huge change in the fees that we've seen, right?
Not for corporate immigration. I think the biggest one that I can see from an increase standpoint is with the EAD. It goes from 410 to 550,
Mm,
which is a little bit higher. But
yeah. And of course, the RFEs being reduced is such a good news for many of our consultants because everybody is afraid of an RFE. I'm happy that you said that RFEs is not necessarily scary, but yep, we want it all to go perfect, right? Less RFEs.
yeah, yeah. And I think like maintenance of status is another, RFE that you see quite a bit, right? So they'll ask for, if you are in H1 status, they'll ask for your pay stubs. So make sure that, your pay stubs are accurate and you're checking your pay stubs. And it's not a related point, but, a lot of times you're on projects, right? And people forget to update their employer or let their employer know because when you're jumping from project to project, your addresses change. You go from one state to another, and the HR department might not know about it. So, as an employee, it is very important to kind of keep that in the back of your mind because I've had RFEs where they've said, "Oh, but you said they were working here. Why does the pay stub say this particular state?" And then all of a sudden now you have to kind of provide all this documentation to clarify that no, everything was as is. It's just we were traveling. With COVID, that might not be a big issue, but just some of these basic things of notifying USCIS, kind of notifying your HR department. It's not just the HR department's responsibility. I think as an employee, you also have to make sure that you're taking the appropriate steps to make sure everything is aligned in your file.
Of course. That's a very important point that you mentioned that your documents, if you could file them all together, because you know what happens when somebody's asked for certain documents, they go hunting that this is what I need and it takes time. So being organized, maintaining a file, and that helps even in RFEs and even in random situations. So it was a pleasure to have you here. Sachin, you have any words that you want to say to just sign us off?
Yeah, Niyati, I really appreciate your time. I have one question, one last question, that maybe like refer to all the team members as well as who are here. So nowadays you are seeing that there are a lot of corporate layoffs going on. Okay, and I'm seeing a lot of H1s that are coming to me and they're asking me to convert them to us. So, but the challenge with them, some of them is that some of them were being laid off like almost like a month, and then they have their pay stubs of July first week or second week. Do you think we can cater those kind of people as well? Like, will it be fine to do their Richmond transfer, or it will be a difficult case for us?
No, so you do have, especially if their status has not expired. I think that's the key. If the status has expired, it becomes a bit difficult. But if the status has not expired and with their previous employer, even if they were laid off, then you have 60 days. So within those 60 days, you can essentially, file for the extension.
Perfect, perfect. Yeah, this
So
is
I would say that just provide the documentation, see if they have I-140, see if they have when their each one is typically whenever you're bringing a transfer case, right? A few things that you can provide that would make the answers on my end very fast would be provide the I-140 approval. Yeah, it's available, it's not available. Provide that. Provide whether there's a H-1B approval. If you have it, then we can actually look at when it's expiring, because sometimes it may not be expiring in 60 days, it may be 45 days. So then that time kind of, it's still valid, but that time kind of gets curbed. So provide that information, provide where they're going to be located, job duty, job title, so that everything gets expedited. And one of the most basic things is what is their name in the passport, because sometimes they go by a different name, and we're starting to work on things based on that name versus what's in their passport. So.
okay, okay, perfect. So I really appreciate Niyati for your time, and I hope like everyone we are able to answer all the queries. So hopefully we'll meet again, Niyati, and then I will share your information with everyone out here. Okay, if you allow me, and then thank you very much, everyone. Take care.
Thank you.
Bye, Niyati.
Bye.